Good afternoon, everybody, and thank you for joining us for our latest in What They Didn't Teach You at School webinar. Focusing in on everything you need to know from a wealth creation, financial planning, really just your personal wealth affairs or personal financial affairs, everything you need to know. And today we're going to talk about death. Exciting topic, isn't it? I know Carrie loves talking about death. No, she doesn't. But it's an important subject that we do need to talk about, and often we find that it's a subject that many people ignore. In earlier webinars around what they didn't teach you at school, we've covered off on cash flow, superannuation, insurance, investment strategies, a whole range of different topics. But to help me talk about death today, joining us, we have Carrie Payne. Carrie Payne's part of the Business Depot legal team and helps deliver estate planning services and so forth. Welcome, Carrie.
Hi, John. Thank you.
And we also have Megan Kelly. Megan is a director in both our accounting and financial planning teams here in Brisbane, but also heads up the superannuation, especially the self-managed superannuation division here as well. So she comes across a lot of these people and a lot of these clients who are thinking about what they're going to do with their wealth after their passing, or of course, in a lot more sort of broader situations as well. Now, of course, as is always the case when we talk about anything financial planning related, what we talk about today is going to be only general in nature, and you should always seek specific advice to your circumstances before acting on anything that we talk about today. We may share some stories with you today. Please lean upon those stories to learn and apply to your situation. But of course, you must customize it to your specific situation and get financial advice from a qualified professional to do so. So let's get into it. Happy to take questions throughout the conversation today. Please try and use the Q&A icon at the bottom of your screen. You can jump on the chat if there's anything you'd like to share, but the Q&A icon does make it a lot easier for us to manage. Now let's get into it. And I'm going to throw straight to you, Carrie, as a lawyer. Tell me, why do we need to have an estate plan?
I don't know if you should throw anything straight to me as a lawyer, John. Maybe as a person will do me, but as a lawyer, maybe not. It's actually a really interesting question because a lot of people they sort of think that that they don't need one. If they've got no assets, they've got no wishes, that sort of thing. And what my usual statement is that you always have an estate plan. It's probably just not one crafted by you. And what I mean by that is that there are fallback provisions within legislation in Australia that say if you don't leave wishes around who controls assets and who receives assets, then the government has a preset or predetermined set of rules about who gets to take those roles and take those assets. So you always have one, it's just not one that's been designed by you. Now, I think that keeping in mind that there are also government bodies that take on roles that we might not want them to. So that's in relation to, for example, managing your estate when it comes to passing away. So this is, getting to be your executor and make funeral decisions over on top of what your family can decide. All right, number two is looking at decisions if you've lost capacity. So again, having to answer to a public body about what's happened to your loved ones, rather than having to be able to make those decisions on their behalf. And also control of other sort of wealth structures such as trusts. If you haven't made or haven't put down a comprehensive estate plan, then public bodies can end up controlling those entities. Now, I think sort of the other thing that I hear really commonly is people say, well, I don't have any assets, so why do I need an estate plan? And there's several sort of points here. Number one is that an estate plan is not about you. Believe it or not, it's not about necessarily your wishes, but it's more so about making it easy for the people that you leave behind to sort of deal with some of the stuff that comes up. So the position is that if, John were my family member, he passed away and I wanted to act for him, but he didn't have a will, I would have to go through a court process of applying to actually be his executor. And I might be in the mix of different sort of group of people that might want to be applying as well. So it's about making it really clean and smooth for your family if something happens to it. It's not just about you. And then there's other stuff as well, just dealing with third parties, even the tax office. If you pass away and you haven't, completed your tax return, I know it sounds really strange, but you're making people like Megan and John's that little bit more difficult. John's job that little bit more difficult. You want to make sure that your family, when they're dealing with third parties, have some sort of authoritative document again, so it makes it a little bit easier on them. I
It's
think,
not, as you say, it's not just about the person that may be dying in this situation. So much of it is about everyone else that's being left behind and what you leave behind. Like, do you leave a mess behind? And then your legacy is actually that you've got 15 years worth of tax returns to do for somebody that didn't do their tax returns before they passed away for something. But in the same vein, estate planning is not just about putting your will in place either, is it, Carrie?
yeah, I mean, I think people get really tied to that notion of a will being what the precipice of estate planning is about. But what we're finding more often than not is that people probably forget to do not just the death aspect, but the incapacity aspect as well. So, we're finding with an aging population, people are starting to lose capacity, and we're getting this larger cohort of people that aren't able to make those high-end financial reasoning sorts of decisions. If you don't have those documents in place, again, your family are going to have to answer to some external body, or they're going to have to go through things like tribunals to get appointed as your attorney to make those sorts of decisions. There's legal costs associated with that. I know one man that just to get appointed for his own father's affairs, it cost him a bit over 10 grand in cost just to do that, whereas you can actually download for free a power of attorney form with advice. It doesn't cost you that much more. So
because it's a bit like the discussion we had with Mitch Hood when we were talking about insurance. In some ways, incapacity is actually worse than death, even though that's a terrible thing to say, in that you've got all these different costs and different things you have to cover for from an insurance perspective. But likewise, in a will and power of attorney sort of situation, if you're incapacitated, someone's got to look after you, and who's going to do that? Which again makes it more about the other people than it is about yourself even.
I say something really quite blunt when I go through estate planning meetings. I say, the will, it won't affect you. You'll be 6 foot in the ground. But the power of attorney documents, so the documents that appoint people to make decisions about you and your assets, that will directly affect you as a person as well. So that's actually probably, from a selfish perspective, should be more important to you because it does affect you directly.
So we've got wills, we've got power of attorneys. What else makes up, I suppose, an estate plan?
So I think when we talk about estate planning, we've got to think about it more rather than just dealing with your assets. We've got to think about it in a way that you're communicating your instructions to people about everything from funeral wishes to, how the children are to be raised, those sorts of things. So there's other documents that you could do to accompany the pure legal documents. So, for example, a letter of wishes, which can have in it, as I said, things about funeral wishes, personal property, those sorts of things. What goes in there and what goes in the will is something you get advice from with your legal team. There's also other documents supporting your powers of attorney, such as advanced health directives, which are kind of the turn the switch on or off sort of documents, giving some instructions around those end-of-life decisions. So the other thing too is that when we talk about estate planning, we want to make sure that we're telling people that it needs to cover all of your assets as well. So you can do the most beautiful will in the world, John, but if you haven't independently looked at some of your assets that aren't governed by your will, the will doesn't necessarily sort of speak to those. So we're talking about here things like trust structures. Okay, trust structures, you can't say in your will, I want that asset in that trust to go to this person because it's not your asset, it's a trust asset. Okay, and similar to superannuation, superannuation is a bit of a weird sort of trust in that, you've got to take active steps to make sure that you tell the super fund who you want to receive your superannuation benefits. So, an estate plan's not just about that will, it's about looking at those other asset holdings as well.
Now, Megan, you're probably across all the different tentacles of an estate plan more than anybody with your work with self-managed super funds, with your accounting and tax experience, within your financial planning sort of experience as well. And I dare say you've seen some that work and some that don't work or are effective or aren't as effective. What is the key to your estate planning being effective?
I think the biggest key to your estate plan being effective is to have all your advisors on the same page. And so taking that collaborative approach to your estate planning. There's no point going to see Carrie and getting her to do up this fantastic will and power of attorney only for us as accountants or financial advisors to set up a new structure or restructure something that doesn't get you to where your end game needs to be and doesn't get your assets to where you know, you want it to go. So there's so much more that goes into it. And as Carrie's already said, there's, you know, not everything is in the will. Some is more around your structures. For example, a self-managed super fund requires you to have a power of attorney if you want someone to step into that role if you've lost capacity. So not having that structuring right and that communicated right to the estate planning lawyer can actually undo everything you've just done. So that's really where I'd like people to sort of start to get that open communication happening. We talk a lot in financial advice about full disclosure. You know, we can't give you the best advice for your situation if you're not being completely open with us. So if you're not talking to us about some relationship issues you might be having within the family group, then you might get different, you know, estate planning advice to if we'd been aware of that.
So what are some of those, I suppose, prickles that we come across then? I mean, you talked there about maybe there's a secret girlfriend or something or other, or maybe there's illegitimate children. What are some of the other things either of you have seen in that sort of space?
Oh, John, I have a doozy for you, which I use, that happened to a colleague of mine. They were signing the final estate documents, which was a series of months in the making because it was a rather large estate. And they decided they'd gone through all the documents. They decided they'd have a bathroom break just before they started all the pen stuff, all the signing. And the wife went to the bathroom and the husband approached the lawyer who was looking out the window at their ivory tower building. And he said, would any of this have to change if I had a child my wife didn't know about? So it happens. It happens so often.
I actually remember a similar situation, actually. There was a discussion about an estate plan in the boardroom and the dad had left and one of the kids, while he's gone, goes, what would happen if I'd been a sperm donor? And obviously I've got other children that I don't know about. Would that impact it? What sort of things do you also come across, Megan?
Yeah, obviously the blended family is very common these days, and sometimes partners are fully aware of it, sometimes they're not. Actually, one of the things that people don't talk about, and it can impact the estate planning that you do, is maybe the competency of the people that are going to inherit. So some, you know, people have family issues, drug issues of their own, and their parents don't tend to talk about that. And I understand no one likes sharing those sort of stories, but it does actually change some of the advice we give about how to protect those people from themselves in the future as well. I guess the other thing that I really see is the, sorry, I lost my train of thought there.
There's also things like, there's also sort of assets that you don't know about as well. So if someone fails to tell you about a specific asset, what about if there's a potential inheritance from somebody else that might be coming into your asset pool? Is that going to be relevant?
Well, it is, depending on who you are. And one of the big things that we talk about is obviously protecting those assets as much as possible. And so if you're in business and you're potentially getting sued, or you've just opened to more liabilities than someone who's just earning salary and wages, and if you have a big inheritance come and drop into your lap in just your individual name, just at the wrong time for you, you could lose it all in that point in time.
And that's why it's as much about everybody else, isn't it? Because you can undo your great estate plan. If great auntie Flo left you an inheritance in your personal name, which was at risk because you were a director in a company when something dire happened in that situation. Yeah. Likewise, the other way, if you've got children that you're leaving it to, maybe they don't want it in their own name. Maybe they want it into some other sort of protected vehicle, or maybe they want to protect it from their spouses or something like that as well. That's a common one I hear. Oh yeah, I want to give it to little Johnny, but I don't want his wife to get it or something like that.
Are you little Johnny in this analogy?
No, I'm not little Johnny in this situation.
No, I guess I usually talk to people about, you know, where they want the money to go. And then we start talking about how we want to get it there. and then in terms of asset protection and things like that. And then we start focusing on other issues that come up, such as tax implications of getting it to that next generation.
And Megan, that's actually very similar to what we do from a business strategy sort of perspective, isn't it? You know, it's a plan. Where are we now? Where do we want to get to? How are we going to get there? What's going to get in the way of us getting there?
And just like any plan, it keeps moving. So we will always talk you through it and keep updating it for you. Yeah.
Yeah. Well, that's probably a key point too. It's not a static document, just like a business plan that you maybe pulled together and you put in the bottom drawer. It shouldn't be a static document that stays as it is, because life changes. Maybe you go and you get a new loan, or maybe you go and have more children, or maybe you get remarried or something or other. Yeah. Carrie, what is your sort of suggestion in that regard, I suppose? Are there sort of key events that we should use to trigger a review of your estate plan?
Absolutely, and the list is kind of how long's a piece of string, because they are specific to your circumstances. But the big ones we tend to see are relationship breakdown, either for you or somebody mentioned in the documents, whether they be a beneficiary or a controller of assets. The second thing is you're looking for a change in, say, the other circumstances of that person. And what I'm talking about here are things like if they've gone bankrupt, if they've got a dependency issue that's arisen, or even just you don't have shared values with that person anymore and you no longer want that person there making those sorts of decisions. Okay. Change in risk status is probably the biggest one that we find. So when we're talking about changing circumstance, we mean, has that person gone out and started their own business? Are they now liable to a bunch of creditors if something happens? And just things like the passage of time. I know this sounds very strange, but the law evolves, okay? And so your documents need to as well. When we create you an estate plan, we have to create you one that would be effective or appropriate if it were to come into place tomorrow. But you want to give it a bit of girth, let's say, to allow for things to evolve and change in that time. But there are just sometimes things that happen that you just can't account for. We're not in control of Canberra. Megan will probably tell you some headaches about superannuation law changing more often than you want it to. But that could really dramatically change the strategy for how you deal with that superannuation as well. So the passage of time is really important just to keep an eye on as well. So as part of your collaborative approach with people like Megan, you know, you want your advisors to be the yearly check-in at least to see what's happening.
Megan, do you have some comments on that?
Yeah, I think definitely the law changes and that we need to revisit the planning because of the law changes. And that's why it's really great when all your advisors actually understand what that plan is, because they've got it as top of mind and they can keep revisiting it. But the super changes are a classic one. So 2017, we had some sweeping changes to the superannuation legislation. Seems to happen every 10 years. And one of those changes actually impacted a lot of the estate planning work that we do. So a lot of our clients in the past, husband and wife, would just leave their super to each other and it would stay inside the super fund and they could just start a pension with it. It was fine. And we didn't have too many complications. But the introduction of all these new rules all of a sudden meant even when a spouse passed away, that money was having to leave that superannuation environment, which meant we had to consider what taxes would be incurred and also what assets had to leave the fund. So a lot of people with self-managed funds, you're talking about real assets, like there's a property or something in there. So you're triggering stamp duty, having to get it out. So we actually went and changed a lot of clients' estate planning to allow for this and to plan it out so that we could get the assets to the right person, but we could also allow for the taxes that would be incurred along the way.
Because, I mean, those changes that you referred to, I think we colloquially refer to them as a bit of a death tax, don't we? When you've sort of got too much money in super, but you've sort of almost got to take it out in that situation, you can end up with a bit of a tax liability, can't you?
Yeah, and I think Australia lives under the illusion that we don't have any death taxes, and we don't call it a death tax, but it's totally there. So your superannuation, there is an element that's called a taxable component, and that when that goes out to adult beneficiaries or straight to your estate, you can be paying up to 17% tax on that on the way out. And 17% of $1 million is quite a lot of money. And if we can do something to change that and reduce it, why wouldn't we talk about it and plan it out?
Is this why there's always those stories about people withdrawing all their super on their deathbed?
Yeah, there is a lot of those stories of people having that check pretty much written, ready to go, so that they can just pull it all out. And again, there's been changes in that case law recently as to who can bank that check on someone's deathbed as well. So we need to be careful of a lot of those rules.
Yeah, and so that collaboration, that working together, obviously the accountants who have that annual touch point with them, it's a great opportunity for them to know of a change in circumstances, to then go, oh, have you updated your will to take this into account, and then go back to the lawyers and have a chat to get that revised if necessary. Carrie, we've touched on there. We've mentioned trusts already, and companies and superannuation funds and those types of things. I know a lot of people often come to me and say they want to change their power of attorney. How does a power of attorney work with roles in things like a director of a company or a trustee of a trust? Does it work?
You've given the hard question. So generally speaking, it's a no. Okay. So, and what I mean by that is that that particular role is separate to your role as an individual. So when you make a power of attorney for you as a person, you are giving up, or not giving up is probably the wrong phrase, but you are assigning your rights as an individual. If you wanted to, for example, assign your rights as a trustee, that generally has to be done separately. Now, I say it depends, which is the famous lawyer statement for we can't really say without getting in trouble from our insurer. But sometimes there are provisions inside those trustees that say if something happens to this person and there's no person to replace them, then it's their attorney under their power of attorney document. So generally speaking, for those entities, you make separate documents, but there are some sort of what ifs inside trust deeds depending on the terms of that trust deed.
Because for a company, for example, I mean, a shareholder decides who the directors are of the company.
Yeah.
So if the shareholding transfers to somebody else, then they've got control, not this power of attorney.
Well, it's an interesting question because if you've got a 50% company, so you own 50% and Megan owns 50% and you were to pass away, John, then your family has to sort of wait it out with Megan and sort of fight to who gets to be the director there. So, you know, what some people can do as an alternative is they can appoint what they call alternative directors to fill their shoes straight away so that there's immediately a representative on the board, or they can appoint an attorney for the company in general. If you're the sole director and sole shareholder of a company, it enables someone to immediately step in. So you'll find a lot of professional services firms like law firms will have someone as the sort of backup in case the main person can't be there.
And this sort of links back again to the discussions we had with Mitch around insurance and the need for businesses in particular to have a buy-sell agreement in place so that it's all locked in, insurance proceeds derived, transfer of shares automatically happens, and we know what the business succession is, I suppose, in that situation. Megan, the complication of business entities within an estate plan, I suppose, does it need to be treated differently to your personal estate plan or your personal succession strategies?
It does need to be treated differently, but you do need to make sure someone brings it all together so that your personal and your business plans do align. But one of the things, I guess, we see a lot of family businesses and we see a lot of adult children sort of going into that family business. And so you need to really sit down and go, well, what assets does that child need to be able to continue that business? And what does that mean for the other children? Do they have to sort of buy those other children out in some sort of format? So there's a lot of extra planning that goes in, and it's not just about moving assets from one person to the next and the generation. It's also about how we can put strategies in place to finance some of that moving around so that no one's being left out along the way.
Because I assume if someone's missed out along the way, there's then a greater risk of litigation if somebody feels they've been hard done by.
Totally. And that's what you want to see. You want to see that they've thought through how it works. And sometimes people will want to openly share that with their children. Because they want to be able to get all of that sorted and the family conflict sorted beforehand. And other times it's better to have the fight when you've gone. So it depends on the situation, really. But the more planning we can do and strategies we can put around those things, the more prepared we are for that moment.
Carrie, do you advocate or recommend sharing with your beneficiaries, typically your children, what the plan is when the plan is put into place?
I think Megan's right. It is it is an individual sort of scenario. I sometimes say that it's significantly easier to have conversations with people while they're alive than they are when they're dead. So, if there's things that you want to say that you don't think will have a negative impact on anybody, you can say it. But then, as I said, each family manages their own dynamic differently. That's appropriate. But what I always do say is that the single most important thing is that people know where your documents are. Okay, I get calls from people I haven't heard from in years, probably 2 a year, and they'll say, Carrie, such and such has died, my long lost uncle. Nobody can find his will. So that's the most important thing I say, and it's an important part of the estate planning that we do. We always provide a letter at the end that says, give a copy of the letter to the people that you've nominated in your family. And that way it doesn't have any content in that letter about what is said in the documents. It just says exactly what documents are, and it's got our details on the top.
Or even just who the key advisors are and so forth. So it's really important, isn't it? Some people don't know, especially.
We've got that letter of wishes, John, and we always suggest to them, put down your Megans and your Johns, and you put down all your advisors into that letter of wishes, so the kids have people to reach out with. Because the really funny thing about estate administration is that there's only a really small part of it that's actually illegal in nature. You're looking at a significant part of it that basically should be headed off by someone that does the numbers.
Yeah, and I'd say that sharing that information as soon as you can, or even making an introduction as you know that you're starting to age, especially. I guess I'm seeing a lot of, unfortunately, some of my long-term clients are starting to get to that point where they just don't have the capacity to continue to run all their structures themselves. And so knowing who to talk to and to bring that next generation through does make it a lot easier, especially if I can start educating them, because they may not have the structures that you've got. They may not have ever been in business
or just the business acumen and financial acumen to know what all this stuff means. I had that exact situation only a couple of days ago with a client. He knew what he wanted to have with his affairs, but he straight away said they are not going to be able to manage this volume of wealth. And I reckon we're going to, with the baby boomers, we're going to see a lot more of great amounts of wealth left in more like family office sort of style structures than naturally just distributed, because no longer are the baby boomers just passing down their house or they're selling their house and giving the proceeds. There is now businesses, groups of businesses and investments that are there, and many of them want those investments or businesses to continue on without them. And so I think we're going to have to get a lot more sophisticated with our structures around these estate plans.
Definitely. And sometimes we can do that restructuring while people are alive and get better tax outcomes than waiting for someone to actually pass away. And it gives more clarity as to making sure the assets are going to the right people as well. But the other thing with the structuring and just getting on board with this is that I see too many people inherit these structures. They don't have that financial education piece and they freak out. So their first reaction is, I just want it all gone. Yeah. And they unwind some really great structures that they should have continued without getting that proper advice, because they're dealing with so much at once. They're dealing with the loss of a loved one and all this extra work that they've got on their plate, and as well as trying to learn something new. So if we can educate them first as to why, it makes a big difference to the outcome for them going forward and their families going forward as well.
Carrie, does that resonate with your experience? Is that sort of why we're seeing an increase in the amount of estate administration services?
Absolutely. I mean, I remember even about 7 years ago when I started law, there was this discussion about in the next 15 years, we're going to see the biggest exchange of intergenerational wealth you've ever seen, because people have compulsory superannuation. They've got property that's worth millions of dollars. They've got structures, those sorts of things. So people are complex now. And it's not just a simple will anymore, like people used to be able to do when their great grandparents passed away. You were lucky to get a house and a bit of cash. So we are having to be a lot more collaborative and working with each other to help clients.
And with so many of our clients having businesses, and gone are the days where, you know, little Johnny takes over the business, like I didn't do. We now have such more complicated sort of structures, you know, like the farmer who, one of the kids works in the farm and the other one works in the city, you know, and they want them to get the farm because they're working in it, and balancing those different things. That complexity, that can all be dealt with through the estate plan, can't it, Carrie?
Absolutely. It's just a matter of all the moving pieces, pulling them all together and getting everybody in the room on the same page.
So letter of wishes sounds like a really good idea, and it's a thing to, and maybe that letter to sort of advise people where the key advisors are or where to go if something was to happen. But where should you be keeping your estate planning documents, Carrie?
So your estate plan, I'm probably the biased one to talk to here, because I'm always going to tell you to keep them with your lawyers. And it's
Megan,
not just
what do you reckon? Should we keep it with the accountants? Or?
Well, you can keep them with the accountants.
You know, like if you're doing that collaborative piece, why wouldn't your accountant, financial advisor and lawyer all have a copy? Because the client's going to call whoever they know to call first. Yeah. And hopefully that accountant knows who else to, or financial advisor knows who else to talk to. Yeah. They're less likely to call the lawyer at times because they've never heard of the lawyer, because sometimes you're not in their lives. Like an accountant and financial advisor are seeing these people regularly. The lawyer's seeing them once every few years. So, yeah, it makes a difference.
I think you're right about when it comes to copies. I think the issue is with originals is that a lot of your advisory teams now don't have big document storage facilities like lawyers do. You know, we have this sort of ongoing obligation. If we store documents, we have certain things about how we have to manage them from there. So that's the benefit about having an independent person. I just don't keep them at home. Please don't keep them in the cupboard at home, because that's where we see fires, floods, grandchildren dragging them out to draw on them, etc.
So, Megan, what are some of those common mistakes or misunderstandings you see out there with estate plans?
I think we've covered off a lot of them. The biggest one would be that set and forget strategy, or that my affairs are so simple, I don't need one. Yep. And obviously, I know we had Mitch in talking about insurance, but a lot of people underestimate how much that insurance is. Yeah. And I've heard horror stories of, you know, an 18-year-old tradie working, his girlfriend's sort of living in his parents' basement, basically, with him, and his few $100,000 life insurance that he paid out when he passed away, and it went to his girlfriend because he hadn't made a beneficiary nomination. Now, I'm not sure how you guys feel, but if I was that parent, I'd be like, what? She's only been on the scene for 6 months. Like,
she hasn't heard that.
If my superannuation went to a boy I was dating when I was 18, goodness me. You
know, and I think that's where people go wrong. It's not thinking they need one, but also they're not getting any sort of education or advice. Even filling out your super application forms, you put a nomination in. The super fund doesn't test at the time you make that application as to whether the nomination was valid or not. And if it's not valid, the trustee of that fund gets discretion. So you can have the money going, you know, for example, someone who's not filled it out, or it was invalid, and there's a family and they've got 2 young kids. Yeah. Maybe the 2 young kids get the money with the parent, and the parent sort of doesn't get to spend that money however they want. They can't just go buy a house to put over their heads. And, you know, it's just things like that. It's like something so little, but it can make such a big difference to everyone's future.
What about you, Carrie? What mistakes or misunderstandings do you see out there?
I think the most complex ones for me, from, you know, a drafting or even just advice perspective, is when people don't understand the legal ownership structures of their different assets. Okay, and this is why it's so important for me to work collaboratively with the other advisors, is that a client will say, oh, I've got this business, and start, you know, I do this and I do that, talking about like it's in their personal name, but it'll be inside a trust structure or a company. And so again, you know, they'll want this much money of the business to go there, and you know, you can do a beautiful will, but it won't even sniff like that. And I had that happen the other day. We were in the signing part of a meeting, going through the documents where we actually put the pen on paper, and the client said, oh, I've got this family trust that is starting to do some things. They've made some micro investing that's gone really well, and I just, it happens so often, and it's so it affects so strongly what happens in the advice piece. So,
and that's before you even think about the tax implications of these different things that we do within an estate plan. Division 7A, superannuation, all those different things, they all can have a massive impact. I'm going to, instead of saying a common mistake, I'd say one of the biggest headaches I see people grapple with doing their estate plan is custody of their children, or who is to care for their children. Often you can't pick your family sort of thing, but where do your children go and how are they looked after? I've often found with people I talk to as that's probably the hardest thing for them to agree on, because they're thinking about the life of their kids.
It's so common, John, that I actually sort of say to people now, and have had it happen very close to home in the Depot family, that you just don't put the clause in if you can't agree. So when it comes to guardianship of your children, if that's the speed bump for you to get over the edge, to get an estate plan in place, and by saying, we'll talk about it later about what I think an estate plan should be, but if that's the speed bump, I can tell you absolutely without equivocation, the family law court have the ultimate decision-making ability when it comes to your children anyway. Yeah. So you can say, I want John Knight to take care of my children. If at the time John Knight's, down snorting cocaine somewhere on Broadbeach, okay, they're not going to give your children to John Knight, okay? So
hope I'm not down there either.
Well, Johnny. No, but I think that, when it comes to those sorts of things, the court has to look at what's in the best interest of your child. So if the people you've nominated don't suit what's in the best interest of your child, they can override it. So you're better off to put nothing in there and get an estate plan that's sort of close to being right than to be the speed bump that you never get over.
Okay, looking to wrap this up, I know we've only got the tip of the iceberg here of what we need to talk about with an estate planning perspective, but hopefully that's given everybody a little bit of an idea of some of the key things to think about. Final words of advice or tips for our audience, Megan?
Oh, I think just be open with your advisors. We see everything. We hold no judgment. And the more that we can work together, the better the outcome for you.
What's like they say in financial planning, that duty of full disclosure probably can't be more important through an estate planning exercise, because little things can make a big impact on the result. Carrie, final words of advice or tips?
Just to compliment Megan's, I think everybody's family's got a bit of crazy in them. So, don't feel ashamed. It's those things we need to know about. But to sort of hang on to what I said just before, an estate plan that is 80% better is better than no estate plan at all. So trying to come over some of those speed bumps just to get something in place is better than not having it in place at all.
Yeah, and I think my tip would be, don't forget an estate plan is not just about you, it's about all the different generations and all the different beneficiaries within your family as well. So make sure they know who to talk to in pulling together your estate plan, or if something dire was to happen. Of course, I need to remind everybody of that what we've talked about today is just general in nature. If you need to think about your specific circumstances, make sure you seek advice from a professional that is specific to your circumstances. So cannot emphasize that enough. I hope we've left you with some value bombs, some ideas, some practical takeaways to apply in your circumstances. As Carrie said, 80% correct is better than nothing. And I think there's a lot of people, I don't know what the stats are, but there's a lot of people out there who don't even have a will, or probably haven't updated it for 20 years or something either. And I can almost guarantee that would have changed, or what you would do would have changed over that period of time. We have another What They Didn't Teach You at School webinar coming up in the next couple of weeks. Do you know what that one's about, Megan?
The next one's on retirement planning. So
retirement planning ties in very nicely to estate planning. Hopefully, maybe we should have done retirement before death. But anyway, and of course, you can get a copy of this video if you want to look back on this and think about your specific circumstances on our website at businessdepot.com.au. You'll also get an email out with a link to that in the next couple of days. But by all means, if you have any questions whatsoever, please don't hesitate to reach out to myself, Carrie, or Megan, or one of our other financial planning team or accountants and business advisors. We'd be more than happy to help. Thanks, everybody.